Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in this video, let us learn about
Noscitur Sociis.
when we look into the meaning of this Latin word, we get into a conclusion of prejudicial statements. Like looking at your friends, I can tell who you are, what kind of person you are. Like we get a prejudicial statements, like surrounding you, what is influencing you, and other stuff. So, the principle of Noscitur Sociis is a rule of construction. It is one of the rules of language used by the court to interpret legislation. This concept means that the meaning of an unclear word or phrase should be determined by the words immediately surrounding it. In other words, the meaning of a word is to be judged by the company it keeps. When two or more words susceptible of analogous meaning are coupled together, the words take their color from and are quantified by each other. The principle here is the meaning of the general words is restricted to a sense of analogous to that of less general word. Coming to the judicial approach, like where this Noscitur Sociis is used in the law. So, in the case of Commissioner of Income Tax versus Bharati Cellular, the term technical services was sandwiched between two other words, managerial services and consultancy services. In section 194G of the Income Tax Act, dispute was whether the term technical services meant a service done by machines alone or a service done through human intervention. The other two terms, managerial services and consultancy services, necessarily involve a human intervention. So, applying Noscitur Sociis, the word technical was also held to be a service involving a human element. So here in this case law, it was said that services include human intervention also, unlike the managerial and technical services. Coming to the another case law of Alamgir versus State of Bihar, in this case, section 498 of IPC is taken into consideration when a woman comes with another person with either with her own consent or with some kind of force, then the person who has taken her either with her consent or without her consent is charged under the section 498 of IPC. So let us go deep into this case law. So enticing or taking away or detaining with criminal intent a married woman. So whoever takes or entices away any woman who is and whom he knows or has a reason to believe to be the wife of any other man. Here, the question is, if she is taken care by any other person, or if she is under the care of her parents, or if she is under the care of her husband, if that woman is taken away with or without the consent of the guardian from that man, from any person having the care of on her behalf of that man, with the intent that she may have illicit intercourse with any person, or conceals or detains with that intent, and such woman shall be punished with the imprisonment of either for a term which may extend to 2 years, or fine, or with both. So in this case, the married woman was living with her consent with the accused. So the accused pleaded that the above section will not apply to him, as the woman, she gave her consent and she came with me. So I didn't force her and I didn't detain her. But the court applied that the principle of Noscitur Sociis will come here, and held that in this section the consent of the woman was not at all relevant. What is relevant is whether the accused person knew about the marriage or not of that woman. So if he has knowledge, then he is the guilty for detaining that woman. So it is as clear as that if that person has taken away the woman with her consent or without her consent, if she is under the care of her husband, if she is a married woman, then obviously the relevant sections will apply to the person. Have another English case law, IRC versus Freyre. In this English case law, the term interest was found linked with Two other words, annuities and other annual payments. When the dispute was regarding the term of the payment of the interest, it was held that it would indicate that the interest should also be paid on yearly basis only. So when the term annually is mentioned, so the interest has also should be paid annually along with other kinds of charges. Another case law, Rainbow Steel Limited versus Commissioner Sales Tax. In this case, an old thermal power plant was sold away in working condition. Existing sales tax laws provided the seller some tax relief when old and discarded, unserviceable and obsolete machinery was sold off. The meaning of the term old was questioned. The court of law applying the above principle of Noscitur Sociis held that the word old must mean the same thing as the other three words. If the machinery was working in condition when it is sold off, even though it was an old machinery, it did not come under the term old as mentioned in the relevant sections of the sales tax laws. So depending upon the surrounding, like what is the things which are old and what comes under the old should be considered into the picture. As such, we have come to the end of the video. It's riddle time. Please answer the riddle in the comment section. Please like, share and subscribe my channel for many more interesting topics. Thank you.